3 p.m. Welcome everyone. I'm Dr. Kyriakos, and this is workshop number 24. For those who may have sort of gone to the wrong room, now it's time to leave. We will talk about expert evidence and what it means to follow the science. This will be about it. Allow me to say that, at least in my view, this workshop has the people who will be able to inform us. Unfortunately, Professor Simon Cole could not join us because he would have to self-isolate for 2 weeks before and after his trip to Europe, so he couldn't join us, unfortunately. So the question we will be discussing today and tomorrow in this full-day workshop in 2 parts, across 2 different days, will be, what does it actually mean to follow the science in a criminal court? Now, as a very brief introduction, before I give the floor to our expert on expert evidence, let me tell you something about the socio-cultural background of all that, of the opinion rule. Don't lecture me. It's something we say in our daily lives, and I'm sure that there's something similar also in Spanish. I know for a fact there's something similar in German, in Greek. So every time someone is giving us information about something that we actually understand as good as they do, we will say, don't lecture me, or something more polite. Right? Unless we will track information, we will track knowledge and go and ask them, because they have the skills and the experience or the knowledge to inform us about something that we don't understand or know. And that's the theory, right? That's the socio-cultural background, the linguistic background of the opinion rule. And for those who are not familiar with the opinion rule or with English law, the opinion rule is the rule of admissibility for any opinion which is inadmissible unless it pertains, it relates to something which goes beyond lay people's experience and knowledge. Right? So, and again, that's the theory, and for at least the past 3 years, we have been hearing that a lot. Follow the science, just listen to the scientists. Again, the question will be, what does it actually mean practically to follow the science? Because, again, especially the UK government has been saying that quite a lot. We just follow the science, they say. The lockdown is basically what the scientists told us to do. Right, and let me show you very briefly how things can go wrong. I realize now this is an informational disaster because no one can read that because of the beamer not working properly. This is a discussion between Professor Graham Medley and the journalist Fraser Nelson. Professor Medley is the chair for the SAGE modeling group. SAGE is the scientific advisory group for emergency, the advisory group for the government, right? And it came out that actually SAGE for these 3 years has been just modeling situations relating to COVID which they did not address as a probability, right? So Professor Medley says here that we don't opine as to the probability of the omega variant being as lethal and toxic as the delta variant, for example. So the journalist was saying, wait a minute. Because the COVID measures were on the basis of the omega variant being as toxic and lethal as the delta variant. And so there was a mismatch in communication. There was communication breakdown, right? Which a guy on Twitter with a profile picture from a horse race called Reg described as scandalous, and I agree that this is a scandal. This is actually the prosecutor's fallacy on steroids. This is what we have in the criminal court on steroids. So, again, this was a very brief introduction into the problems and why they are important also beyond the criminal process. And now I have the great pleasure to introduce you to Professor Paul Roberts, and in the unlikely event that anyone in this room does not know who Paul Roberts is, Paul, you're a professor at the University of Nottingham with an affiliation at CUPL in Beijing. I won't list your accomplishments and your achievements. I will only say congratulations for your recent fellowship at the British Academy. Allow me to say that it's richly deserved to see someone without expressing political opinions that are favorable to the mainstream academia getting this fellowship. So, floor is yours. Allow me just to change the PowerPoint. Is it full screen? Or?
Should be. Well, I think it's. We'll see. Well, yeah, thanks very much, Kiri, for that over-generous introduction. Thank you to all of you for coming. Just a word on our friend Michele Tarufo. Great shock and great sadness that he's gone. He really was a scholar and a gentleman. If you knew him, you'd agree completely. And people like Michele, Jordi Ferrer, Paul Vasquez, and others who take on that mantle of doing research, speaking at conferences, and organising fantastic events like this across not only disciplinary but also linguistic boundaries, which is so important. I'm enormously grateful to have been invited by the Northumbria crew to be part of this panel, but it's also a great honour to be speaking at this event, the inaugural Michele Tarufo Evidence Week. So my title, as you see, is What's So Special About Experts? This seems a fairly basic question to ask. Notwithstanding, Kiri said, I'm sure there are people who don't know me. So if you don't know me, you might not know that I've been working on this topic for, I guess, 30 years now. 30 years. And, I keep coming back to these basic questions. I'm very much hoping that each time I come back to these basic questions, I've actually learnt something along the way, and that I can address them in some manner that is informative and moves the debate, the policy debate, the scholarly debate, the research debate onwards, and that I'm not trapped in some kind of horrible academic Groundhog Day. But anyway, you'll inform me about that as we proceed. So, what's so special about experts? Let's see if this works now. I start off with the thought that certainly in my jurisdiction, and I think I can generalise to the common law. Those kind of generalisations can be problematic, but in this instance, I'm going to generalise to the common law. We treat, at least, we treat experts as exceptional in the sense that they're not like ordinary witnesses. There's something extraordinary about experts. I'm calling this expert evidence exceptionalism. More precisely, there are different ways in which conventionally, traditionally, we think about experts as special. And I'm running through an enormous amount of stuff here, very general way. Other speakers will illuminate particular points, but just in a very simple thumbnail sketch, there's doctrinal exceptionalism. Doctrinal exceptionalism relates to special rules of evidence. Kiri's already mentioned the opinion rule. There are other rules relating to experts, for example, to do with hearsay. I'll say a bit more about that in due course, which are special for experts. So there are various ways in which experts are doctrinally exceptional, certainly in the common law jurisdictions. More generally, we can talk about a kind of institutional exceptionalism. Now, obviously, doctrine is institutional as well, but I mean this in a much broader process sense. We treat experts differently to the way in which we treat, as it were, ordinary witnesses of fact. And this is, it's represented in all kinds of ways. For example, experts could be court appointed, and of course anybody from the civilian tradition is very familiar with that as an idea. Can happen also in common law jurisdictions to a certain extent. And as I say rather delphically on the handout there are also special procedures and duties which attach to expert witnesses. I'll say more about what I mean by that in due course. So we've got the doctrinal, we've got the institutional, process stuff. Also epistemological. We conventionally accord to experts a special, privileged epistemological status. Okay, you're familiar with these ideas. And this is how I know I'm a lawyer and not a philosopher. I always have to cite the case. So I just want to show very quickly that I'm not making all this up. So this is not the famous Turner. If you know common law or English evidence law, you know the Turner case. This is not that Turner, this is a different Turner, much more recently. Just want to confirm that there is such a thing, which Kyriakos alluded to as the opinion evidence rule, as it's often said. Expert evidence is, of course, an exception to the usual evidential rule that witnesses cannot express an opinion. An expert cannot express an opinion within the proper scope, etc. So, the opinion evidence rule is alive and well in 2020 in England and Wales, but of course you can find it in Wigmore and Thayer. It's 150 years old. And, we could go beyond that as well, but there's a broader question about whether evidence law really exists before about 150 years ago, but let's not go that on to that. So that was an example of the doctrinal exceptionalism. This is a process issue. Something that's very important now in England and Wales, and I won't elaborate on this today, but it's an incredibly important development that we are increasingly relying on norms of criminal procedure which are not really properly law, or they're a secondary legislation, or they're guidelines or rules. They don't have the status of a continental criminal code. So we have this thing called the criminal procedure rules, and the criminal procedure rules lay down special duties for experts. Again, this is another example of exceptionalism. Of course, all witnesses have duties. Ordinary witnesses of fact are under a duty to tell the truth to the court. You know the phrase, the truth, the whole truth, and nothing but the truth, whatever that means. But there are special duties for experts, and if you're reading ahead, if you can actually see this, I don't know if you can you see this? Right at the back? Does it make? Yeah, no, good, thanks. And you can see this unbiased, objective, etc., etc. Special duties. And the epistemological status of expert evidence starts not with the law, but with more pervasive social norms of conventional understandings. And this is an example of a relatively early DNA exoneration in the USA. Certainly, a number of people in the room will know this already. Maybe perhaps everyone doesn't, but it's a great example. The guy's exonerated through DNA evidence, and he says, I guess he must have got this from the lawyers, I don't know, but anyway, DNA proved that he was innocent because DNA is God's signature. And God's signature is never a forgery. That really encapsulates for me the epistemic status of expert and particularly scientific evidence. Now, so that was obviously an example from the news and from media and social media nowadays. You can find lots of examples of this in the case law. These are not important precedents, they're not even reported cases for the most part. But you see within the way that judges talk about expert evidence the special epistemic status that it has. These are just, by the way, comments, obiter dicta, as we would say in England, of judges in particular cases, in court of appeal cases. And you get reference, and these are quite recent ones, these are all, just go back to Ron Allen's point from the first day or second day, these are not pre-21st century cases, these ones are 21st century cases. Unassailable scientific facts, the court is referring to. More examples. I don't know why it's doing that. Let's have a look. Get more discussion here. The issue is not important. For my purposes, it isn't important. It's not important for my purposes. The court is saying that it's very difficult to prove this type of offence because there is very little or no scope for independent verification of the accusation by scientific or other objective means. You get the idea. It's scientific, it's objective, it's unassailable. This is a very, very recent case where the court is drawing a distinction between scientific certainty and what it calls legal certainty. Again, who knows what that means? But at any rate, the point of the dictum is that in law we don't need scientific certainty. Science has got the best certainty, but we don't need it. Something less than that will do for us. And again, I'm milking this a little bit, but I do want to emphasise, it's important to me, that the claims that I'm making are not just some theorist claims, it's not just something that's come out of the classroom. This is in the decisions. This is how judges speak. Mathematical certainty, decisive proof, it's another example. So, by the way, the point of those examples, and they're simply illustrations, is not to show that judges are idiots, because they're not. And it's not to show that they haven't got a good philosophical theory of science or proof or truth if you press them on it. But that's not how they behave in their everyday job. The point is that in their everyday conduct of business, they make these kinds of assumptions, and they're exactly the same kinds of assumptions that you might find quite pervasively in society where we supposedly follow the science and that will save us. So the basic idea, this is the famous Turner, the basic idea of expert evidence in England and Wales is that we have experts because they are in some respect helpful. That's the key test. And I don't want to get into the doctrinal niceties of all of that. Just hold on to that idea that the epistemic status that we're discussing now is related to the notion that they are helpful in some way. Now, and this has already been alluded to earlier in the week, following the science raises questions about epistemic authority and hierarchies of epistemic authority. What do you do in a common law system like mine that is strongly committed to lay adjudication in serious criminal cases, fact-finding by juries? What do you do when common sense and scientific rationality, objectivity, all of those unassailable things, what do you do when those two things appear to conflict? There is a conflict there of epistemic authority. Many of you, perhaps all of you in the room, just about all of you already know that the orthodox answer in England and Wales, and in the common law more generally, is that experts are there to educate the fact finder so that the fact finder can itself make its own decision. It's trial by judge and jury, not trial by expert. And there's loads of cases that repeat this as a principle. Now, it's all very well to say that, but in reality, there are situations where the tension between common sense of the jury and the rationality of science as an epistemic claim, there are situations where they come into quite direct conflict. How do you resolve that? Well, since we're just amongst friends, we don't. We fudge it. There is no clear epistemic hierarchy in the relevant cases. Where it comes up, judges fudge the issue. They say things like, well, you know, if there's no rational basis for the jury to depart from what the experts have said and it's all agreed, then really the jury ought to follow what the expert has said in that domain with regard to that question. I think Kieran might have some more to say about that later on. But it's not really a proper resolution. One of the, you might think, I was going to say one of the great things about the common law, it's kind of an ironic remark, one of the great things is we don't have to resolve these questions because we're not very committed to theories of anything. So, pragmatically, we have a process and we do our best to resolve these issues on a case-by-case basis, and we live with the contradiction. Between ourselves, cognitive dissonance is not a problem for the common law. So, in a nutshell, that's why conventionally we think that experts are special. But hang on a minute. There are various streams and strands of revisionism going on, not only culturally, but also within the law. Some of you may recognise our friend there. If you start to put pressure on the alleged bases of the claim to being special for expertise, it's not very difficult to problematise the notion that expertise or experts or expert evidence truly is special. So, if you like, in the first part of my talk, I've done thesis, conventional view. We're into antithesis now. Let's look at it from the other perspective. It's not too difficult to put pressure on this. And none of this, by the way, is new thinking. The first point is in Thayer in the 19th century. And it's the idea that although you can talk about facts and opinions, the distinction between them is not conceptually robust at all. You know, what is a fact, what is an opinion, is very debatable, depending on how you phrase the issues. And this is not simply a conceptual claim, it's a claim about whether you can have anything that resembles a robust opinion rule as a way of distinguishing expert from non-expert. And to cut a long story short, you can't really. Turns out that many experts give evidence of facts. On any defensible conception of a fact, they are giving factual evidence. And conversely, lay witnesses often give opinions, in the sense that witnesses in ordinary conversation, in ordinary testimony, often report their interpretations of primary facts. This is to say nothing more than what you can find in Kant, which is to say that it's all interpretational. You know, the empirical world is a matter of interpretation and it's contingent. So, it's very easy to problematise the fact-opinion distinction as an appropriate way of distinguishing expert and non-expert. On the second basis, I've reversed this a bit, on the second basis, the epistemic status of expert evidence, this again is very problematic, and I could say an enormous amount about this. I've written about it, as many others have. The essential point is, though, that we often allied expert to scientific. And there's a lot of slippage in the discussion between expert evidence and scientific evidence. The fact of the matter is that much expert evidence makes no pretensions to anything called science. I mean, just a very simple example of this, and this may be true in your legal systems as well, a simple example would be that in English law, questions of foreign law or questions of fact for which you need an expert witness You need an expert lawyer to testify to the fact of what the law is in another jurisdiction. Now, that's not science in the way that that word exists in English. You know, it might be Lex Wissenschaft, but it's not science in English. So, turns out, and it's pretty obvious, lots of people in the room have done work on this, Gary's done loads of work on this, lots of other people have, Carole, Tony, and everybody really. Many of the claims to expertise that we encounter are highly contextual, and the methodologies that experts employ are radically diverse. It's very difficult to generalise acceptably about them. And then, in a much more straightforward way, we know about the fallibility of expertise and the association of expert evidence, including scientific evidence, with miscarriages of justice. And Samuel Gross was talking about that, for example, earlier on in the week. So, we come now, how am I doing for time? I've got 5 or 10 minutes left? 10? 15? Okay, good. We come now to what really got me thinking about this topic again. It's reading this paper of Fred Schauer and Barbara Spellman, where they ask this question, is expert evidence really different? And they develop many of the arguments that I've just been discussing in their own way, but roughly speaking, there's congruence there between what they want to argue and what I want to argue. Their basis thesis is, no, they're not that special. And they address the fact-opinion distinction, talk about that. They worry about the distinction between what counts as expert evidence and what counts as lay testimony, particularly as, of course, whilst we think about these categories perhaps as separate, in reality, you know, scientific wisdom becomes common sense, doesn't it? There's a constant traffic between scientific discovery that, when it happens, looks miraculous. I mean, think about the invention of the internet. Think about trying to explain to your grandparents what the internet was going to look like. They think you were crazy or that it was kind of magic or something. But very quickly, these things become part of ordinary common sense. One of the points that Schauer and Spellman make is it's a bit weird if we're so hypersensitive about experts testifying to expert knowledge when lots of lay witnesses can just come into court and say stuff that's based on science the scientists apparently are not allowed to say. Bit of a simplification, but that's the part of the driver of their argument. Making the point that, in many ways, the way in which expert evidence exceptionalism has played out in evidence law is irrational. That we're over-concerned with the problems of experts, and we worry about this, particularly in the US context with Daubert and everything that followed from that. But on the other hand, we worry about that. We don't worry enough about the fallibilities of ordinary witnesses testifying in the way that they do, right? And then, of course, when you think about ordinary witnesses testifying to ordinary people in the jury box, you can compound misconceptions and biases and all the rest. Common sense, in its various guises, is kind of getting a free pass and being overvalued, while at the same time we're hyper-vigilant for experts. And they say, it just makes no sense. If a rational approach would bring the two much closer together in the way we think about expert evidence. Now, they don't say this, but it struck me that it's not a very big leap from these kind of arguments to a much more sceptical view of expertise, which brings us back to our friend Michael Gove, who quoted on the first slide for this part, who famously said we have enough of experts. That's not quite what he said, but you can come back on me on that if you're interested. Here's a much more general thesis about a sort of general collapse of the epistemic authority of experts. Default expertise is the expertise, or at least right to judge, that ordinary citizens feel they possess because science and technology are so valuable, which comes to justice. if experts do not really possess any special expertise, if the emperors have no clothes, then surely, that's always a, surely we are all scientific experts now. Possessing default expertise means being as good as an expert because there are no experts. Now, as I say, that's not what Sharon Spellman say, but the thrust of their thesis is certainly consistent with that kind of further inference that you might want to make. Thesis, antithesis, 10 minutes for synthesis. There's something wrong with the story. Something wrong with the revisionist account that experts are not so special after all. In a nutshell, I want to argue that they are special, but not necessarily in the way that the common law has conventionally imagined. What really makes experts special is not really the things we traditionally, conventionally pick out, certainly in evidence law, as what is special about experts. So this is the synthesis. I think I've got 8 minutes left for exceptionalism reconsidered. Now, there is an older literature, for some reason often cast out in the metaphor of personal relationships, about the supposed incompatibility of law and science. The idea that law and science are in some respects two worlds apart. They have different protocols, different methodologies, they make different epistemic claims. So it is a marriage of opposites. Don't opposites attract? Anyway, marriage of opposites. There are perhaps, question mark, irreconcilable differences. There is a culture clash, and of course that goes back to two cultures and a much longer history of the argument, C.P. Snell and all of that. Now, if you know my work, you know that I've never bought the culture clash argument. I always thought it was wildly overstated and not very well informed about institutional facts. I mean, one institutional fact that you need to start with is expert evidence, including scientific expert evidence, is by definition oriented to the ends of justice. That's why forensic science is not just science. Forensic, remember, means pertaining to the law. It doesn't mean scientific. Otherwise, forensic science would be science. That's not what it means. Forensic science means science for law. That means that if you want to be a good expert in the context of, say, criminal adjudication, if you're interested in doing expertise for the administration of justice, then you have to accommodate the processes and the institutions and the cultures and the values that you engage with. If your science is too good for law, you're no good to us. Remember the principle that you've got to be helping. So I've written various things, including most recently a book that I've collaborated on with my Northumbria colleagues, various people who are in it. Again, setting out some of these points, and others develop them more thoroughly. So, when I first read the Shah article, I was kind of thinking, yeah, I agree with that. And then I thought, well, hang on a minute. This has not gone to quite the right place. There's something not quite right here. So in the last 5 minutes, this is my attempt to say why I think there's more to be said. I think there are genuine differences. And I'll run through this quite quickly and hopefully pick up in discussion. I think there are differences on the evidential level, and one that you might think about is that expert evidence is routinely, typically, exclusively, maybe not exclusively, but normally circumstantial rather than direct evidence of criminality. And its circumstantial status is significant because it means that you always need to make further inferences from scientific evidence in order to arrive at legally relevant conclusions. And it's often in the making of those inferences where problems arise, not so much necessarily with, as it were, the science, when it's good science. Institutional differences. Experts are, not always, but largely fungible in a way that lay witnesses aren't. If you're a trial lawyer, you've got the lay witnesses you've got. If there's an eyewitness, there's the one eyewitness, you can't swap them for another one. Experts are fungible in this sense, and thus this gives rise to all kinds of issues about the way that we select experts and choose them. In some contexts, you can worry about expert shopping of various kinds. In a civilian juristic context, you can worry about how the judge chooses the expert, and are they choosing their pet expert, are they choosing the orthodox expert as the court expert. There are worries there that don't arise with ordinary witnesses of fact. I think it's terribly important to think about the way in which many experts are repeat players in litigation. Not all of them, but many of them are. Certainly if you think about forensic scientists, they're doing their job. And that again makes important differences for lawyers when we think about credibility and the reliability of expert evidence or forensic evidence, more specifically forensic science evidence. And one thing that jumped out at me is the track record of a particular expert in testimony and in the way that they write their reports and provide their reports. It itself becomes a factor in trial. So credibility is a dimension of expert witnessing that, of course, we worry about the credibility of lay witnesses as a fact as well, but it's different with experts because we at least potentially have different resources, including their track record, for interrogating their credibility and reliability. And finally, and on this, and I'll run through the last quite quickly, I put this in square brackets because I don't really know what to do with it, but I think there's an interesting fact about the way in which expert evidence or scientific evidence or forensic science has kind of become its own academic discipline as well. There's kind of a sort of separate literature. It's not completely separate, but it's sort of floating free from what I would regard as the mainstream core of evidentiary scholarship. And that's good in some ways because it demonstrates the importance and the strength of expert evidence and scientific evidence as a field, a subfield, a specialism. And it means that there can be, well, Kyriakos made these points in relation to me, experts on experts who do this kind of thing. But I don't worry as well that that specialist literature might become detached from the core literature of procedural law or evidence more generally. And there might be some dangers there. So I just flagged that. Let me try and bring things a little bit to a close now. I think on each of these dimensions, we see familiar problems with experts that are truly distinctive in some respects, either because they raise issues you don't get with lay witnesses of fact, or because, although we do get these issues with lay witnesses of fact, we deal with them in different ways, owing to the fact that we're dealing with experts. For example, it's necessary to modify the common law hearsay prohibition, because if you applied it strictly, which by the way we don't in England ways anyway, but if you just generally do it in the common law world, it would prevent expertise from operating, because experts typically draw on lots of other stuff that they can't vouch for. So there are doctrinal adjustments that are made there that are a necessary part of making expert evidence helpful. And there's also this issue about quantification and statistics as well. Often the debate around this is phrased in terms of, well, how can we quantify everything else? And then there's a worry that, we haven't got quantification for other kinds of testimony. I think that might be misplaced, that debate. I think it's much more interesting to say something like, well, we can quantify some things. We do have random match probabilities for DNA profiling evidence. So the good news is we should use them. If we've got quantification, let's have it. I'm not afraid of numbers. I don't think lawyers should be afraid of numbers or statistics. Of course, the key thing is that we actually understand what's going on. And moreover, that as professionals, whether we're judges or lawyers or academics or whatever, that when we understand what's going on, we have a fighting chance then of explaining to the fact finder what's going on. Now, in my jurisdiction, that translates into the need to develop what Edmond's recommending now, but we call forensic reasoning rules. These are, broadly speaking, the rules that inform trial judges about what they have to say to juries when they approach evidence that's regarded as tricky or difficult or likely to lead to prosecutor's fallacies or whatever it might be. So it shapes out as forensic reasoning rules in England and Wales. In other jurisdictions, it will operate differently. But at any rate, quantification is both an opportunity and a challenge for the law, and it is a genuine difference about experts. I want to say a little bit about, really, 2 or 3 last points now. My feeling is that all the time we've been talking about experts, and we should have paid more attention to the idea of professional witnesses. I think that the professionalism of witnesses is a significant dimension of what's going on in expert evidence. And that professionalism can be linked to many of the things that I've been talking about already, like for the fact that many experts are repeat players. They are, if you like, and I know this sounds pejorative, they are, if you like, professional witnesses. But being a professional witness comes with special responsibilities. And this is not about opinions, it's not that. It's about the special responsibilities that attach to being a repeat player and to giving circumstantial evidence in criminal adjudication. And Tony's afraid now I'm going to give his paper. I don't have time anyway.
Don't worry, it's a different paper.
It's a brilliant article about essentially police officers as experts or other officials giving expert testimony about rap lyrics and gang subcultures and trafficking victims. Nothing to do with science, as you appreciate. But again, the salient issue here is really about the professionalism of witness. I'm not afraid of the concept of professional witness. I can't go into the details now, but English law does have a concept of professional witness, and it uses that concept to say this person is not an expert because they're not giving opinions. That's nonsense. That's the wrong focus. Where we see centrally that it's the professionalism itself is the issue, then I think we can address that more directly. Epistemic authority, we need to resolve that. In case you didn't know, Harry Collins' answer to the question, are we all scientific experts now, is no, we are not all scientific experts now, because it turns out few that genuine expertise, which is domain-specific, methodologically sound, and relevant to the proceedings, should attract special epistemic authority, because it has the authority of being more likely to be true than other forms of information. That's something then we have to negotiate within the trial. So there is a specialness there. I want to pull back from the sceptical conclusion about experts. So to conclude, really, this is a great quote. I don't know if you know the Evelyn Waugh quote, which is, "Up to a point, Lord Copper, this means no." So in the story, the editor avidly agrees with the paper proprietor when the paper proprietor says something he agrees with. He says, yes, Lord Copper, I completely agree. But he doesn't have the guts to disagree. So whenever he disagrees, he says, "Up to a point, Lord Copper." So that's my feeling about this thesis. My conclusions are banal, in a sense that none of this is new particularly. All of these things have been said before, some of them by me, but however though, I'm going to keep saying it for as long as I detect that the message is not heard. We have to find a way of achieving not juror education, which I think is, for the most part, not possible, but a form of rational deference or rational reliance that we can have confidence and faith in. We need to pay close attention to the comparative law dimension. That's come out a number of times this week in the conference. I think that's a brilliant aspect of what we've been doing here. You know, at a very general level, all modern legal systems face these problems of science and whatever that is, of scientific methodologies, of hierarchies of epistemic authority, of the loss of faith in experts, of what you might more generally call social epistemology, and the way in which social media has affected all of that, and alternative facts and disinformation and all of those things. All of us face that, but legal systems resolve those difficulties in their own unique way to a certain extent. And I'm quite big on context and culture and procedural tradition. We need to be talking about those things as well. It makes it more tricky. We have to pay attention also to not just the doctrinal law, but also to the institutional realities, not just the law in the books, but the law in action, the socio-legal dimension, if you like, or the process dimension. And the final methodological caution. William Twining has coined many memorable phrases. One of them relates to generalisations, factual generalisations in particular. Twining says factual generalisations are necessary but dangerous. We have to generalise to make sense of the world, to navigate the world, to say anything useful. We're always generalising, but there are always risks in those generalisations to do with cognitive and other biases, with the perspective, all of those things that psychologists quite rightly inform us about. So Twining says, necessary but dangerous. What I find in this field is that too many generalisations are unnecessary and therefore gratuitously dangerous. So my advice would be, don't overgeneralise. Mr. Jassier,
Right, so let's have 20 minutes for discussion. Who would like to ask the first question? Tony?
A great paper. I suppose.
You mean yours or Paul?
No, I mean his, but I mean, it's something I spoke what I'm going to say tomorrow. And the thing that's been worrying me about my own work, actually, and maybe about this as well, is, we talk about, on one hand we talk about rational, well-warranted difference is what we want. And on the other hand, I mean, you point out quite correctly that in practice judges fall back on this sort of unreflective trust in science to deliver unassailable truths. And I just wonder whether, is this whole quest for rational, well-warranted deference kind of unrealistic? I mean, should we accept that it's always going to be about some kind of only partially rational trust in science and build our reform proposals around that?
So, thanks, Tony. So let me now, in discussion mode, try and be a bit more nuanced and reflective, because these are difficult. That was a kind of general presentation, but these are difficult questions. So, one thought would be, if moral truth is pluralistic, which pluralists believe and utilitarians don't, but if it is, this means that there are plural values. And plural values will be a fact about the world. And we can argue about what kind of fact it is. I don't want to get into the ontology of moral epistemology now. But whatever the basis for that is, there will be multiple values. Right? If that's true of a general theory of justice, it's going to be true of a general theory of criminal adjudication. And it's also going to be true of a general theory of criminal adjudication in England and Wales. So the first thing I would say is that we shouldn't necessarily expect judges to tie everything up in a bow for us when it comes to value conflict. I mean, it seems to me pretty obvious that English criminal adjudication is committed to rationalism in principle because, we exist on this side of the Enlightenment and not the other side. So I think Twining is broadly right about the rationalist tradition. But we're just as emphatically committed to lay adjudication, and we're committed to lay adjudication owing to a set of political values that is to do with democracy and the importance of ordinary people having an input into criminal adjudication, which is from top to bottom a moralised enterprise, right? So what you see, I think, in quite a tangible way, is these values butting up against one another. Now, some people think, as you will know, that moral particularism is the truth about morality. Now, if moral particularism is the truth about morality, all you can do is resolve it on the instant case. And that sounds like something that would be very hospitable to the common law method. I don't think I buy particularism, per se. But what I will say is, there's ways of chipping at this problem, and you've written about in your work, Kim, I think Kim's going to talk a bit about it as well today. There's ways of chipping at this problem that means that the opposition is not as stark as you would have imagined. Typically, the way of doing this is to recognise that the expert and the jury are not answering precisely the same question. And once you start to resolve exactly how and why the expert is helping, for example, it's on the slides, but I can speak about everything. For example, I think we'll all agree that experts don't testify to normative facts, whether those normative facts are legal facts or moral facts. They don't testify to them, generally speaking, they're not asked to do so. That's the job of the jury. So if we figure out what the jobs are, we can start to not dissolve the problem, but to ameliorate it. This is a, almost Wittgensteinian contextualism resolution, which allows us to have our cake and eat it, to be both rational and committed to jury trial. And by the way, they're not the only values. There are other values in there. If you know my book, we identify 5 in particular. Accurate fact-finding is one of them, that goes with rationalism, but procedural integrity is another. It seems to be very clear that English law today is committed to what the Americans would call due process, procedural due process. And that's an integral part of doing justice in criminal cases. And that makes things even more complicated. But again, we cannot discharge the responsibility to do justice by following the science. And of course, we should follow the science, but that won't give you the answer, is the point. And of course, that's what they had to say in the end. I mean, in the COVID context, the scientists themselves ended up having to come out and say, at the end of the day, Boris, you decide.
Can you speculate why Boris Johnson always says, or has been saying for a few years now, not me, I'm just following the science?
Yeah,
they
rode back from that in the end. They had to row back because the chief scientific advisor and all the other top science people, in fact, again, I don't know where I picked this up, this is hearsay, we're amongst friends. I heard that Patrick Vallance was on the point of resigning unless Boris made it very clear that Boris was taking the decisions, not Vallance. Vallance was only advising on the COVID situation. The policy, the politics, that was for the politicians.
Yes, the gentleman. Yeah.
Just a question about the opacity of expert testimony. You were just talking in your answer about the different values inside the judicial procedure. And there is maybe one difference between expert testimony and lay people testimony regarding the possibility of the judge to enter into the foundation of those testimony. And if it's not possible, maybe this is maybe the difference in the case of the expert testimony, while it is possible in the case of the lay person, because it's always level of technical language that is understandable by the judge. I don't know, I'd just like to know what do you think about this problem that expert testimony or also expert fact-based norms opposed to the fact that we want judges to take the decision and not the experts like you said knows about.
Thank you. Yeah, sure. So, I mean, you know, first of all, that dynamic is unavoidable, isn't it? Because the expert is an expert. That means they know things that the fact finder doesn't know, and that gives them power. So there's always that difficulty always arises. Whom can you trust? Whom can you trust? Now, of course, this plays out differently in systems. You talk about the judge. Now, the way I think about it is, how should an advocate make the jury understand? So the responsibility is more on the lawyers in the case to effectively cross-examine the expert witness. Now, sure, cross-examination for an expert is going to go differently to cross-examination for a lay witness. You're not going to be trying to say the expert is a liar. Well, it could be, it happens occasionally, but for the most part, you're not going to be saying the expert is a liar. You're not going to be saying that the expert is prosecution bias or something like that, for the most part. But you will be saying things like, what did the police tell you? What information did you get? What are your assumptions that you've based all of this on? And then you just go through. Isn't it possible that this could have happened? Isn't it possible that that could have happened? What if the samples are contaminated? Does everyone in your field agree with you? Anyway, any expert who replies to that yes is mincemeat, because there is not one scientific field where everyone agrees. Then you can say, well, look, here's this textbook. This seems to disagree with you. What do you say to that? You see, I'm talking about adversarialism really here. And all of these things can be abused. Sometimes cross-examination amounts to an abuse of power because you make honest, truthful, reliable witnesses look dishonest or untruthful or unreliable. Often, cross-examination is completely ineffective. Gary's written a lot about this, and I broadly agree that it is often ineffective. It's routinely ineffective. But it should be effective in at least pointing out to the fact finder what the domain is and exactly what the meaning and value of the expert's testimony is. And by the way, I am firmly of the view scientific evidence is never on its own dispositive, ever, ever, ever. There is always other information in the trial. So when anyone ever says to you something like, can DNA on its own prove guilt? The answer is always no. Always. Because there's always other information. Starting with what the accused said, or what he or she didn't say. That's another piece of information. There's always other information in the trial. And there's always a context. You know, you might have got a DNA match, but if that person was provably 1,000 miles away at the time of the offence, something's gone wrong with that DNA match. So the prosecution always has to deal with other possibilities in the trial. So, I think, you know, you want to say cross-examination is ineffective. I want to say it... I want to say that if the thought is that cross-examination is a fantastic tool to ensure the reliability of expert evidence, you're right, it isn't. Right, you can't cash that check. But I don't conclude from that cross-examination is useless with experts.
I don't either.
Well, we agree.
I think it has great potential.
Absolutely.
It just rarely reaches that.
We agree.
Yes, next is the gentleman there in the back.
Thank you very much. My question is not directly related to an expert witness, but yes, with expert knowledge in court. So, what will be your opinion, taking into account these insights about the role and the functions of expert courts or specialized courts and tribunals? Would you think that these same insights apply, or it would be different, broadly speaking? Yes or no?
So that is a perfectly good and sensible question, to which I'm going to give a rubbish answer. And I'll explain why. I'm a criminal lawyer and I know about criminal law. I don't know about adjudication more generally. I'm not an expert on civil procedure or on tribunal procedure. The most I can say is it depends. It depends on the area of expertise. It depends on the kind of issue that is to be adjudicated. I mean, if someone comes to me and said, you know, well, I practice in family law, it's very different in the family courts, the way we deal with experts is totally different, there are child protection issues, etc., etc. My response would be, good, I know nothing about that, to be honest with you. So I don't have the expertise to answer your question. I think, like all good experts, I should say when I don't know. I don't. It's a great question, though. What would be your answer?
I don't know. I have several instances. I know my fields of expertise is environmental law, and environmental law is a field where several countries are sprawling specialized courts and tribunals. And I don't know. Sometimes I think that it's more for a political reason. Sometimes I think that it's really because the topic is very difficult to apprehend for the lawyers, so they need to have some specialized agents or judges who are not really educated in law. But I don't know. I think that there are several insights regarding this. But
I mean, behind this, there is the worry, isn't there, that modern society is just too complex. Do you know? Go on.
No, yes, because one of the critiques about this would be that taking that point of view, all the different fields in law are becoming more and more specialized.
Yeah.
So if we are going to have specialized courts with specialized agents in these courts, well, there will be no more regular courts, so we will need to have specialized courts for everything. For computer contracts, disputes, I'm not really sure if that it's really a problem. That would be.
Just very clear, I do want to say that I do think that criminal adjudication is special because there's something special about a political community censuring and sanctioning individuals for serious public wrongs. Something to do with the nature of criminal guilt and with the nature of censure for that is not replicated necessarily in other areas where you might want to take a much more straightforwardly market-based or commercial or quote-unquote utilitarian or consequentialist approach to maximising the public good. And that might be true of, say, areas of environmental law, for example, or anything that's to do with regulation of the market as well, I think.
Yeah, that's something interesting in this because I am not either specialized in criminal law, so that's your field. But I know that there are some sanctions related to the government, but punishes with criminal or with.
Sure, yeah.
So everything is getting complexity. Maybe you're talking about everything is getting interrelated. But what will be there? Who will take the punishment? Specialized court in environmental sanctions or a regular court specialized sanctions?
Right, the lady.
Yes, forgive me if I say something too obvious, but it seems after your presentation that there is a problem of communication between science and law. And scientists are in their business, doing science for their own purpose. And it seems that we lawyers, we judges, need to be worried about create strategies to incorporate science because we need science to resolve some issues. So the point may be making a broad generalization should be working on these communication tools about how to translate conclusions in science to the law field.
Great question, yeah. I mean, this is absolutely fundamental. I talk to lawyers, I talk to scientists and forensic scientists and others as well. And there are kind of no innocent parties in all of this. It's very easy for the lawyer to get what they want from the expert. They want an answer, they want a conclusion that supports their case, or the judge is looking for something from the scientist. And if they get it, the temptation for the lawyer is not to look too closely about how they got there. You know, it's too easy. It's like this idea of, you know, Bismarck sausage. If you like the taste, you don't want to know what goes into it. And on the other side of it, you know, I often find that experts are too ready to say, well, you know, I'm just a scientist, I don't know anything about courts, I'll leave it to the lawyers, or leave it to the judge, let them take responsibility. And I think, as well as communication, as you rightly say, it's absolutely fundamental. And I did a project a while ago with a forensic scientist and a forensic statistician, and we spent a long, long time talking to one another. And it took years, if not, well, months if not years, I should say, for me to even understand what they really meant. All the basic terminology, basic ideas, the frameworks, I mean, you know, they tend to work in, broadly speaking, empirical or mathematical paradigm. I'm working in a justice or normative paradigm. That's my starting point in criminal justice. Point being, if it took us all that time, you know, people who notionally know what they're talking about in their own field, having genial conversations together in classrooms and over dinner, years it took us to understand each other. What chance has an expert got in a courtroom talking to a judge or a jury to really achieve that mutual understanding? So it has to come through all kinds of initiatives, absolutely including education, absolutely including how we teach law students and all of that. But also I just want to add to the communication, taking responsibility as well. Just to add and link to the last point, criminal law involves us as a political community saying to another person, you've committed a serious wrong for which you will be censured and seriously punished. We all need to take responsibility for that. It's no good that the lawyer looking the other way, the judge looking the way, the expert looking the way. People need to take responsibility. I talked about professionalism. Part of professionalism is doing your job and taking responsibility for it. So, communication, absolutely. It's hard, but it needs to be done. Along with that, taking responsibility, because people will be trusting those experts, they'll be trusting that evidence, and trusting the lawyer and the judge to do their job in dealing with that evidence appropriately. And you know, we need to take responsibility for that.
Right. Quick one.
Okay. I guess this relates to the issue of communication too, and finding a more sort of balanced attitude among judges towards scientific evidence in courts. On the one hand, as you pointed out, we of course don't want them to be overly trusting of the experts and have no ability whatsoever to, you know, do their own analysis of whatever is being said. But on the other hand, we also don't want them to be overly skeptical, right? And I can give you an example for the International Criminal Court to estimate age of child soldiers. There's a lot of forensic evidence being presented. And there's a citation from one of the cases, which is, so the forensic expert does a relatively good job, I would say, in communicating limitations of forensic age estimations. But the judges are completely categorical in relation to what's being said. And they conclude that our experts have said that this is not a precise science, so instead of trusting the forensic age estimations, they go on to trust their own assessments of the alleged child soldier's physical appearance to estimate age. So that's the other, you know, side of the spectrum, so to speak.
Yes.
Do you have any examples like that from the match lawyer system? I've seen a few like that too.
Well, whenever, that's a great point. I mean, whenever expert evidence is excluded, there is always the risk that they will just resort to their own horribly biased perceptions, or, you know, make big mistakes. And this is a pervasive problem. I mean, I think it's really interesting that you raised the supranational level, because I talked a little bit about the importance of sensitivity to procedural context and comparative law. When you add in the international, supranational dimension, where you've got multilingual panels of judges who don't speak the same language and come from different cultures, this is enormously complex as well. So it comes back, for those who are in the panel on Fred Shah's book this morning, it comes back to the information being good enough for the purposes for which it's adduced. Now, this is terribly complex when you want to talk about international criminal adjudication or even international human rights law, where courts are laying down generalised norms in relation to incredibly problematic situations, sometimes to ongoing conflicts, etc., etc. So I just think maybe it's again the common lawyer, but I think you have to be pragmatic at some level. What you do have to do, though, Noah, is always to look at the option. So it's a mirage to say this is not perfect, so we won't have it. That's a big mistake.
Yeah.
You should always say, what's the alternative? Because when people say to me, oh, identification evidence is not reliable, so I say, well, okay, well, let's rely on people who weren't eyewitnesses then. Will that improve things? Not really. It's a question of, relativities.
Right, so, many thanks. Right, good time. Should be it. Alex, it's Control and L. Large. Right, so hi again. I'm Kotsoglou. If you remember what was Paul's third or fourth slide, trust me, I'm a doctor. My paper is all about that. It's all about fleshing out the argument lurking in this situation where a physician, a doctor, medical doctor says, trust me, I'm an expert, I will tell you what you should do. This paper is all about that. So the question, what should I do? Convict, not convict? Think that this is substantial impairment? Please keep these words. I will come back to that later. And in the paper I will explore what we call with my colleague and friend Alex Biedermann the decision-making prerogative, which was mentioned before during the discussion. Who decides what? So I will try to attack this concept of exceptionalism, not by showing that it's wrong, but by constraining it to some specific tasks, and show that we can identify rules of authorization, and show who does what, the jury does that, and the experts are doing that. And this is all I can do, being a lawyer, or I should say being an analytic Tlzenian lawyer, who doesn't opine about which are the right values. I'm constrained by the values of my legal system. I don't address them as a moral problem. I just take them, systematize them, and show that they can show us how the problem dissolves, as Paul said. Right? So let me see how this works. I have a question for you. Anyone knows what this is?
Yeah, I do.
Yeah, let's raise hands and reveal your age. Right?
53. Even once I went to a concert.
Right. So 2003, Star Sailor released their second album, I think. Love is Here, and the way I see it, we are among friends, so actually Love is Here in more senses than one. One of the songs of this album is this one, Paul Misguided Fool. This was actually a PowerPoint presentation. We turned it into PDF. I cannot click on the link to show you the song on YouTube. No worries, I will not sing. You will not suffer in my workshop. These are the lyrics. Can everyone read them? Right? Let me just read them for you. They say, I quote, "You're just a poor misguided fool who thinks they know what I should do. A line for me and a line for you. I lose my right to a point of view." So if you know where I'm coming from, conceptually, doctrinally, you see why this song, these lyrics basically encapsulate everything that I have to say. I will come back to that a bit later. Let me just link my paper, or my presentation, it's our paper with Alex, to the common thread of this, the way I see it at least, one of the common threads of this evidence week. The issues around forensic science, right? And feel free to ask why I use inverted commas. Right, and Jennifer Manukin was talking about that. You have already seen multiple times a version of this slide, not my slide, but something similar, saying that look at all these Blue Ribbon Committee reports from the National Research Council 2009, the PCAS, the President and Council of Advisors for Science and Technology, or the House of Lords in the UK from 2019. They all say the same, they make the same claims. We have faulty forensic disciplines, wrong analysts, underperforming laboratories, lack of protocols, lack of scientific validity, lack of standardization, and also the problem of individualization, right? For those who don't know or don't remember what individualization is, it is the forensic claim that reduces the possible donors of a forensic sample to one person, and says, the expert says that this forensic DNA sample has the defendant as its source, or the victim, the witness as its source, so that the forensic expert individualizes the forensic sample, right? So now the problem is because we have all these issues in criminalistics. I don't like the term forensic sciences, and basically now you know who asked the question to Jennifer Manukin about whether we are allowed to use the word forensic science. Criminalistics have too much noise and do not allow us lawyers to focus on these rules of authorization, to ask the question, who is doing what? Because first we need to solve all these problems. We need to discuss and resolve the problem of having wrong analysts and disciplines without any validity, such as tool mark analysis or earmark analysis, right? So from the point of view of information management, from the point of view of information as a basic unit of analysis, we have too much noise there. We cannot detect the signal because we have too much noise, which explains and predicts why lawyers and expert evidence lawyers, scholars, focus on DNA evidence. Because DNA evidence is the only discipline, this is what has been stressed in every report, has validity, right? Although we have gone through a long process of the DNA wars, the way I count it, we have 3 phases of this DNA wars. DNA War 1 was about validity at the end of the 1980s, where we didn't have enough understanding about the base rates and the scientific basis of DNA profiles and hypotheses. DNA War 2 was about logical fallacies, right? The prosecutor's fallacy, or the defendant's fallacy. And if you think this is a thing of the past, only in February, in R.V. Ahmed Farad, the Court of Appeal actually committed once again the prosecutor's fallacy. So it's with us, but still as a field of, as a discipline, we have discussed that. And the third phase of this DNA war is about the decision-making prerogative, which will answer the question, who decides what? Who will individualize? Who will say that the defendant is guilty? And who will say that this DNA sample has the defendant as its source? Because if you do that, you basically preempt the outcome, right? For reasons that we'll all understand. If someone as an expert with their authority places the defendant in the scene of the crime and not 10,000 miles away, then we are halfway there to a conviction, right? So this is why what I've been working on for the past 6-7 years, and this is actually the logical process that we have followed, right? With these papers, the first one was in 2018, where we introduced vocabulary, the decision-making prerogative, and as a concept, as a specification of the Kelesenian concept of rules of authorization, who decides what, when, under which circumstances. And then we proceed to the third paper of the inroads into the ultimate issue rule, right? Which is what I will talk about today. And the ultimate issue, for those who may not be familiar with English law or common law, is the one that says that juries decide cases, which was reiterated partially in R.V. Biedermann, right? And was brought into conflict with the principle that decisions must be based on evidence. Now, in R.V. Biedermann and Golds from the UK Supreme Court, these principles were brought into conflict. And I will try to show you that this conflict is basically a misunderstanding, a miscommunication between science, between forensic experts, and criminal adjudication and criminal scholarship. Right? So what we try to do is we try to break down the process of approaching expert evidence to components and identify in each process logical steps where experts make decisions. Although I claim they shouldn't. They have no authority in making decisions. Right? Even at the stage of the match report. Let me show you this. This is how a full match looks like when you can superimpose the forensic sample on the evidence sample, so that you have a that they map onto each other. Now the problem, the devil lies in the details, right? We know that. It's never a full match, and especially when it was done manually. Experts tell us that the threshold for a full match is 5%. Now the question is why? Who has fixed that, determined that threshold? Why 5%? What about 10%? How would a defendant feel if they saw that, yes, it's not really a DNA match, it's a 5% possibility of error match, right? There's something there that is decisional in nature. It's not scientific. There's an element of decision, and not courts, neither courts nor the jury makes the decision. It's the experts who make this decision. So I see there a problem, right? So, so just to say a few things about the doctrinal framework in which this paper, takes place, right? So expert evidence, according to English law, needs to be two things, at least two things. Reliable, Paul mentioned that already. So we need a sufficiently reliable scientific basis, at least for scientific evidence, and helpful, right? And although my referencing is not as smooth and complete as yours, Paul, right? So R.V. Turner, the famous Turner, not the one from 2020, if on the proven fact judge or jury can form their own opinions without help, then the opinion of an expert is unnecessary. So please keep in mind that admissibility is predicated on whether it's necessary. When the jury does not have the common sense, the common experience or the knowledge to understand the evidence at hand, right? This is when they need help, right? Because being helpful is always a thing. Just think what our relationship with our parents is always a conflict about how to help. They want to help us. They wanted to help us, and we have tried to push back, saying, "You're not helping me." Right? This is, I think, a good example about the friction in this R.V. Turner dictum of helpfulness. So, and again, this is the doctrinal framework in which we have to operate, right? And we would say that the expert witness is bound to testify within his or her area of expertise, within, not go outside, and any step outside his or her area of expertise constitutes a usurpation of the realm of the jury. You cannot enter territory of the jury if you're an expert. You have to opine about your area of expertise. And again, my claim is that this is very helpful. This shows us something. It confines the experts within an area of expertise. But it's not sufficient because it doesn't explain what this area of expertise actually means. What it means to follow the science. What it means to follow the expert. Especially when you have unchallenged expert witness testimony, expert evidence. Because this problem surfaces when you have unchallenged expert evidence, as it was the case in R.V. Brennan and Goals, right? Because if we have experts saying different things, we can pretend that we resolve the issue or fudge the issue because we just say we pick the expert that tells us what we expect. We also would say if we would have to decide. But with unchallenged expert evidence, when they both say you have schizophrenia, and so this would make it likely that you have also substantial impairment, which is the main element for one of the partial defenses in English criminal law of diminished responsibility, which would bring the sentence from murder down to manslaughter with all its differences in the legal consequences, right? This is where the problem surfaces. So now the problem is, again, without, it doesn't say much. It doesn't explain what it actually means to abandon your area of expertise. And why is this the case? Well, you mentioned William Twining, Paul, who famously said that we tend to reduce evidence to the, I would say, procedural rules of evidence. We tend to uncritically oversimplify a complex concept, the concept of evidence. So, to do that, let's go back to your slide number 3. I lost count, right? So trust me, I'm an expert. Let's try to think about this problem in a very simple way. Let's think about the situation where someone goes to their GP, to their physician, because they have, well, something is wrong. We cannot tell what exactly, but something is actually different. Headaches, right? So, and the blood test analysis shows some carcinogenic tumor markers. You know, the white cell sort of density is 97. I don't know if I'm talking utter nonsense, but let's say it's 97, which for them means something, but for us it means nothing. Right? So that's the first question. What does the data tell us? We have a tumor marker of 97, 95, it doesn't matter. Now, of course, you would say, no one cares about numbers. All we care about, especially if this is the patient, the question is, what is going on? What is the problem? Is it something that is suspicious, that indicates a serious condition? So we don't really care about data. We care about information, right? Which is more than data. And this is important, and which people in the AI and law discussion usually conveniently forget that data and information are not the same. What we care about is, what should I believe? What is the diagnosis here? Data is what it is, but what should I believe? Do I have cancer or not, right? So what is the diagnosis? And of course, the medical doctor will say, well, we have some competing hypotheses, because there's never a slam dunk diagnosis outside the context of Dr. House, right? There's diagnosis number 1, say leukemia, blood cancer. Apologies for just bringing this all up. I know it's unpleasant. Second diagnosis, second possibility, bronchitis, something trivial. And third possibility, false alarm, nothing, health, the person is healthy, right? So at some point we need also to answer this question: what is the diagnosis? And if you think about it, this is actually the same problem. No one really cares about the diagnosis. All we care about is what can we do to resolve it, to tackle a problem. So the question is not only what the data shows, not only what the diagnosis is, but also what should I do? And if you think about it, the question is, of course, who will answer this question? Is it the doctor or is it the patient? Before the Second World War, before the Nuremberg trials, it was always the expert, the doctor who would say, yeah, you will do this. But obviously, nowadays, that we have autonomy as a legal value, as a moral value, we wouldn't allow that. It is the person, it is the patient who will have to choose between, say, chemotherapy, surgery, or palliative treatment, or just do nothing. Go to the pub, have a pint, and wait until they die. Right? Now, this is important. It all depends on the values of that, on which this patient operates. Whether they value human life, whether they want to prolong their life, whether they want at any cost have a therapy, or whether they just accept the inevitable and say, well, too bad, my time has come. And we can discuss about whether there are objective values in the universe, but each person has different values, right? Someone values life more than others. And if you think about it, this is relevant. Why? Because legal systems are nothing, the way I see it at least, as a set of political and moral values enshrined in statutes, statutory law, legal principles, case law. So we put these values into law. So the question, what should I do, again, requires the input of values. Now, what I want you to keep in mind is that to answer all these questions, to answer the question of question 2, we need more than the data. We need also some differential diagnosis, right? To arrive at a conclusion and to also decide what we need to do. We also need more than the data and more than the diagnosis. And this is interesting because we can see that we have what we treat normally, uncritically, as a unified concept, if we look closely, has 3 different questions. So our main concept in evidence law, and I'm an evidence lawyer, is not a homogeneous one. It includes 3 different questions. The first 2 ones, in my estimation, in our estimation with Alex, are the inferential elements, right? Those who will tell us, well, you have schizophrenia, dear defendant. Or this is sort of a typical case of leukemia or blood cancer. But these are inferential elements. They can be based on science. This is what normally experts tell us. Now the third one, and again, apologies if none of it is legible and you cannot read that. The third one, question 3, what should I do, is not an inferential one. It's not an epistemic one, as it were. It is a decisional element. It requires the input of values, right? And I hope you see where I'm trying to get at by dividing these 3 questions into different discrete steps. The inferential ones and the decisional one. All right? So, the question now is, given that there are 2 different contexts, the inferential one and the decisional one. Who will decide, right? Because for me, again, being a boring Kelsenian scholar who doesn't opine about societal issues, who doesn't go on Twitter and say this is right or wrong, who doesn't criticize the government with the academic hat on, I can do that with my moral hat on, but I have no authority I have no moral authority, I have only doctrinal authority, right? The only thing I can do, that's my only tool, and I claim it's a powerful tool, is to answer the question who has the decision-making prerogative, who decides, and also who should have the decision-making prerogative, the lege ferenda, right? Who should decide. Now, again, it is in my mind clear that English law, German law as well, and also this is similar in other legal systems, it is the jury that decides, right? Remember R.V. Brennan, Paul mentioned this case. Lord Justice Davis in R.V. Brennan said that it is the jury that decides the case. But then it needs to be based on evidence, right? And the question is, well, if we want to criticize that, if we want to sort of understand what is going on, is it the right thing? Should we change it? Should maybe the expert have the prerogative of deciding? And I want you to take a second to think about that. Think whether experts know more than us about which values are the right ones. Now, unless you are natural lawyers who think that the legal system in which we operate is invalid just because you disagree with the system morally or from the point of view of your religion, so unless you're natural lawyers, you are with me in saying that there's no one who has moral authority over others. And there's only one entity, and this is not in this world, right? It's only God who could tell us which values are correct. So we don't operate within a religious framework. So, and because there is no such thing as a university of life, I'm using David Runciman's phrase, there's no such thing as a university in which we learn about life, about decisions. There's no such thing as a decisionist, someone who is expert in making decisions. Someone, because if you think about that, decision is basically a leap of faith, a jump that is unwarranted. It must be based on evidence, but as such, it is not a scientific phenomenon. It is a jump. So there's no such thing as a jumpist. There's no such thing as a university of life, where experts should also tell us not only what we know and what we should believe, but also what we should do, right? Each legal system has its own values, and the jury is there to implement these values. Also, in the situation of the interpretation of ordinary words, right? Think about the case of Brutus v. Cossacks, where Lord Reed in 1970 said, we need to leave ordinary words alone, because no one is an expert on the definition of the word hostility. No one knows better than anyone else what hostility means, what substantial means, because for the partial defense of loss of diminished responsibility, we need substantial impairment of someone's cognitive skills, right? So the expert could tell us whether the defendant had schizophrenia. Question 1, question 2. But the expert, the psychiatrist, cannot tell us whether the impairment caused by schizophrenia is substantial for the purposes of the partial defense of diminished responsibility. The meaning of substantial is up to interpretation, right? It's an ordinary word. There's no such thing as a semantic expert on the definition of a word. Right, so you see where this is leading. We see that when the problem is that all this time, because you mentioned the education, that experts educate, the dilemma in this discussion is either you educate or you defer. Now, my claim is, and this is the claim in the paper, that it's this dilemma, educate or defer, becomes a problem if we assume that we will treat this tripartite analysis, these three questions, in a unified way, as a package, right? As a methodological package, so that one person will answer all three questions, either the expert or the jury. But of course, we can be more efficient, more intelligent than that, and saying, well, what we thought is a unified concept, a monolithic phenomenon, comprises three different questions. Question 1, question 2, question 3. So I'm tempted to say surely, but then Paul would give me the look that the word surely reveals some maybe arrogance. Question 1 is for the experts, right? Of course, in a rational society, question 1 has to be answered by the experts, who will tell us whether we have schizophrenia, whether we have a DNA match. But question 3 is for the jury, right? The jury will tell us whether the impairment is substantial, whether the possibility of transfer, DNA transfer, is reasonable or not. No expert can tell us in a valid way, in a scientifically valid way, whether it's reasonable to think that there's the possibility of DNA transfer, whether the doubts are reasonable or not. Right? So what we do is we say different tasks that need to be dealt with by different people, the expert and the jury. And feel free to ask, what about question 2? Let me say this is a problem, and you know now what the next step in this project is, and what the next paper will be about, because it's more messy than question 1 and question 3. So, how much time? You mean 5 more minutes, and I'm done. So, as I told you before, it surfaces in situations where we have unchallenged expert evidence, right? So, before I say only a few, 1 or 2 things about that, let me just summarize the paper, because I talked about a medical example, and maybe it was not clear how it translates into doctrinal analysis of the law, right? So, what I try to say, what the paper, Alex and my paper tries to say, is that legal decisions cannot be reduced to scientific conclusions. Question 3 is not to be reduced to question 1 and 2. Don't think that I'm saying that it should not be based on evidence, on expert evidence, but it will not be reduced to expert evidence. The expert will not preempt the conclusion, the decision. And this also applies to the issue of individualization, where the expert individualizes the forensic sample and says that this DNA sample has the defendant as its source. Why? Because individualization contains an element of a decisional one. And the expert is not authorized by the legal system to resolve uncertainty. They have no authority. They have no methodologically warranted expertise in resolving uncertainty. The jury is as good or bad as the experts are in making decisions under uncertainty. All right? The other way. So this means that the correctness, not in the court of appeal way correctness, but the logical correctness of the verdict does not map logically onto the treatment of scientific findings, especially if they're unchallenged. So what does it mean? Let's go back to R.V. Brennan and Golds in the UK. Apologies for using cases which may not be known to you in other systems. In this case, both experts agreed that the defendant had schizophrenia. And the jury, despite the unchallenged expert evidence, said, well, we will not convict for murder. We will convict for manslaughter. Right? No justification, no reason for decisions, but we can assume, we can infer that maybe they rejected the expert evidence. And this was the issue in R.V. Brennan, right? And they said that these are principles that can be in conflict. The conflicting principles, right? R.V. Brennan, the two principles that A, in criminal cases, the cases are decided by juries, not by experts, but at the same time, juries must base the conclusion on the evidence. Now, again, my last thing for today, I think I'm over time. The question is, do we have a genuine conflict between these two cases? I say not necessarily. Why? Because the jury and the experts answer different questions. Question 3, what should I do for the jury? And question 1 and 2, what is the data, what is the diagnosis, what is the hypothesis for the experts? So just because the jury, in the case of R.V. Brennan, in the case of Golds, but also in the case of R.V. Morrison case, I forgot the name, sorry. Just because the jury convicted for manslaughter, not for murder, right? Because they accepted the partial defense that requires substantial impairment, does not mean necessarily that they rejected the evidence. They just said, yes, we have, maybe they said, we don't know, but it is possible, and I think it's likely, but they said, yes, question 1, we have schizophrenia, but it was not substantial. The impairment caused by schizophrenia was not substantial. So there's no conflict, because no expert is in a position to tell us whether the schizophrenia caused substantial impairment. Why? Because the meaning of the word substantial is not, right? It's not a scientific issue. And because we can see that, and we can just have an intelligent, an efficient division of labor by saying these are the rules of authorization, the jury is authorized by the legal system to reach a verdict, and the expert is only authorized to talk to us about not everything, question 1 and question 2. There is the reason that I say there is no conflict, there is no real problem. It dissolves, and it dissolves in a very in a way that is Wittgensteinian in nature, right? It just dissolves. It's not solved; it dissolves, because we can identify different questions and different steps, inferential and decisional in nature, in the concept of evidence, which is deeper than we thought for a long time. That is just the rules of admissibility. So the concept is deeper, and this is basically the first step in trying to explore this depth. So that's all for now. Thanks very much for your attention. I guess I would need someone to chair the discussion, because I wouldn't want to be the one who coordinates the discussion. Tony, would you?
Okay, fine.
Federico.
Hi, Keith. Thanks for the presentation. Well, my understanding is that, in your opinion, what's distinctive of the third question is that it involves the consideration of the values at stake.
Sorry, say again, sir.
My understanding is that, in your opinion, what is distinctive of the third question is that it involves the consideration of the values at stake.
Yes.
Okay, great. So then we can redescribe the question as, what should I do given what is at stake in adjudication? But then I think if we describe it in these terms, I would say, by and large, the question is answered by the legislator, not by the jury.
Yes.
Okay.
I'm a positivist.
Okay.
This is music in my ears.
As in, it is the legislator that, through setting the standard of proof, vicariously decides the case, in the sense that, I know this might be controversial to some, but largely what the jury or the professional judge has to do is engage in an epistemic test, finding out whether even the evidence, the standard of proof, has or has not been met. Now, of course, I know some people in the room, and they argue that, and I'm not necessarily against this, that what is a descriptive, as a normative point, the fact finder has the ability to treat the standard of proof by taking into account values that are specific to the case. So I don't disagree with that, but by and large, the answer to that question is an answer that has already been given by the law. Is that something that you agree with?
Yes. So
I think it's mistaken to put it as a binary choice between expert witness or fact finder or adjudicator. You should also take into account the legislator.
Take into account, sorry, what?
The legislator as a
Yes.
possible decision maker.
Just to clarify, and I think because this is recorded, this is verifiable. I said that the jury will implement the legal values, the moral political values enshrined into law and legal principles, right? And anywhere else than Bristol, where we just have jury notification, see the statute Doppler sort of acquittal, the jury should feel constrained by the values, liberal, authoritative of the legal order. I'm not addressing this. I'm saying the jury has to implement that.
But I think, if I may, I think as you put it, it's a bit too vague. So it's not just about implementing the values that are enshrined in the law. There is a decision rule, a standard of proof, that is informed by those values. And the fact finder has to work with that decision rule. So it's not the same as saying, like, the legal system is informed by certain values. There is a specific rule to be applied, which is informed by those values. And it is chosen by the law, which, by choosing that rule, vicariously decides the case, such that what is left for the fact finder to do is by and large an epistemic task. Does it? That's okay. Well, stop.
Let me try to say something and tell me if I understand this correctly. All right? So the SOP, good example, is the best example of a legal norm, rule, where we have moral values enshrined. If we want to minimize erroneous acquittals, we raise the SOP, and vice versa if we don't, right? So unless you would say these two outcomes are not related, as we heard on the first or second day. So what I'm trying to say is that, of course, yes, I agree. It was not meant to be sound as binary as it may have come across. The jury also has epistemic duties, but in terms of who decides whether this situation should mean an impairment is substantial, whether the daily transfer is a reasonable possibility, that's not something that needs any expert to opine on that. The expert should remain silent. The expert has no epistemic authority on opining on things that are also for the jury to epistemically process, right? Remember the helpfulness test. If the expert sort of opines on the substantial impairment issue, opinion rule kicks in and says, no, don't lecture me, don't say anything. You don't have any authority over the jury to tell us whether it's substantial. You're just a psychiatrist. Why would we need to know, to hear your opinion about that? Does it clarify?
Okay.
Yes, it does. We can
let's.
Thank you.
Sorry, Christian, yes.
I want to continue your point here because I agree completely with where you're arriving with this. But the question is, what exactly is the argument for that division of labor? And in your version, it's very much about that okay, since they're not a science of values, it's not the job for the expert to speak on those issues. But I do think that there is, fundamentally, it's a question about political philosophy, because even though there is no science of values, I could decide to appoint you as a moral authority on some issues that I have to make decisions about. I could do that. I'm free to do that. I mean, some people might think it's
You being the legislator of the Constitution.
Sorry.
You being who?
Me, Christian Dorman.
All right.
Yeah. I'm not an institution. So, the interesting thing, people might think this unwise, since there is no science of violence, but I'm free to do this. I'm free to appoint you as a moral authority for me and to have a moral prerogative over certain of my private decisions. But the court isn't free to do this. It isn't, even if the court would believe that there is a science of values. So it's not just the fact that the law has values. I also have my values. But the court isn't free to appoint the expert as a moral authority for the law. Why? Because it's in this division of power, it's not only that the court, the role of the court in deciding on these issues, which are normative issues, is also an obligation that the court has under the Constitution, that the court is not legally free to assign to someone else. So it's fundamentally an issue here of political philosophy, of a system of government where it is designed in a way to place the responsibility for those decisions on the court in a way that the court is not allowed to assign to outsource to someone else. So I think that is a fundamental thing that which has nothing to do about whether there's a science of values or not.
Yes, and the.
Are you following what I'm trying to say?
I'm agreeing. I think we just talk about the same thing using different vocabulary, which is natural because we have come from different disciplines. Let me say two and a half things. The first one is the law has the Midas touch. Whatever the law touches becomes not gold as with Midas, but it becomes the law, right? So the moment the law, the legal system touches a value of political philosophy, it becomes the law. So in that sense, I don't see any contradiction there. It's of course open to the legal system to say, well, and not just the legal system, right? Our former law commissioner, Professor David Ormerod, said, let the experts opine also on the topic of whether the impairment is substantial or not, right? Since they deal with the case about schizophrenia and all that, let them also opine on the moral issue, if you like. I say, in terms of what is the law, who has the prerogative of deciding, it's clear, it's the jury. Who should have the law? We are sort of entering sort of philosophical territory. I say, let's go back to Aristotle, right? And I'm not doing that because I'm Greek, I'm doing it because there's a point there that if you diversify the process of decision making by diversifying those who make decisions, you also diversify errors, right? And this is also one of the claims that David Runciman makes, that you decentralize biases, errors, and also the process of decision making. Therefore, it is actually good. It is also from the point of view, maybe, of political philosophy. See, Aristotle, who is, well, one of those who can talk with authority, it is not actually a bad solution that the law has made to let the jury decide. Because we can diversify biases, errors, and have a more to include more people in the criminal justice system, rather than just a small elite, if you like, of experts who are not experts on political and moral issues. Make sense?
Yeah. Just to supply a bit of information here that people who aren't from our jurisdiction may not know, the background to the Bremen case is that the legislature, in fact, changed the definition of diminished responsibility in a way which arguably did transfer more of the decision-making to the experts by requiring them to find specific capacities were diminished. But they still left in that word substantial, which leaves that...
Yes, this is the epicenter of the problem. Who will tell us whether it's substantial, right?
Which is...
I'm not disagreeing with you. My point is simply that the fact finder court is not simply invested with the power to decide, but is invested with a duty to decide, because it's unlike me, it's unfree to assign someone else as an authority on the issue.
Oh yes.
I think that is a fundamental reason for the division of labor that you're describing.
I never talked about power. This is not part of my toolkit. I'm a boring positivist. All I talk about are rules of authorization. Who is authorized by the legal system, as you would say, to have the duty to decide. Because you have to decide, right? You cannot just say...
I'm also a positivist. I mean, it's a power that the Constitution gives to the courts to decide
Well,
the case.
we can talk about whether we have a constitutional rule there, but yes, I agree.
I'm not sure who has the decision-making prerogative when this part of the session ends. Did you want to finish to move to the next paper at 5 o'clock? In which case,
yes, I think we are over time because
case, I think that
we can have a small
that
short
time
break.
is up, and I'm sure Gary can ask
Yes,
a question
yes.
later.
Right, so I realize we are all under time pressure to catch the bus, so I will very briefly, and I stress that very briefly, I would like to say more about one of my closest collaborators, friend and colleague, Professor Alex Biedermann from the University of Lausanne, who was also the co-author of the paper I presented. He will talk to you about issues around ML. So Alex, the floor is yours without further ado.
Thank you very much, Kiri. Good afternoon, everyone. Welcome back after this very short break. I'm extremely pleased and happy to meet so many challenging lawyers. As someone having a scientific background, it's a pleasure to communicate with so many specialists in law, procedural law, philosophy of science. The topic I will bring up this afternoon is one that I consider a more messy topic about something that's going on in forensic science and forensic science publishing that I thought would be relevant for the lawyers to know about. And I would like to share some critical comments about what in these streams of publications is going on. So there's a stream of publications now that is claiming to use machine learning and machine learning architectures to come up with abstract devices that claim to perform forensic identifications. Notion of identification, individualizations, we have already heard about this afternoon by Kiri. And just to be clear, it's a testimonial statement by a forensic scientist that associates an item of evidence, trace material, with a particular single source to the conclusion of others. And these identification claims are being made since a long time in forensic literature, but at the same time there is a continuous stream of foundational discussion in forensic science, but also in legal literature that has pointed out the conceptual limitations and the empirical limitations of forensic identification conclusions. But despite this fundamental literature, which goes back, for example, to people by David Stoney in the early 1990s, it was a very short paper that has the title What made us ever think we could individualize using statistics? Up to this point, hasn't been rejected or disproved in any of its argument, but still, it continues to be ignored. And there, you can literally take any recent issue of the major forensic science journals, and you find at least one paper that claims to perform identification conclusions. And one recent stream of publications, which I call machinism, is a stream of literature in which forensic scientists attempt to program abstract devices that claim to do identification conclusions. So, specifically, the claim that I label machinism is a stream of literature that has as an idea to assign the comparison process, forensic comparison process, including the conclusion stage of source attribution, entirely to machines. And more specifically, this claim is that the machine should be able to go beyond what is the expert able to do, what the expert is able to do. So this raises the question I would like to discuss or bring out as a question for the debate later on is, or the question that troubles me is to say, if forensic identification is something conceptually impossible, in the sense that we cannot write down a discrete finite procedure that brings us from an observation in a defensible way to an identification conclusion, if we can do it as a human expert, what made us think that we could make a machine do it? Because if we would want a machine to do it, we must somehow tell the machine what it should do. So we must somehow program the process whereby we go from observation to conclusion. So that's the paradoxical question which has intrigued me and that I was trying to investigate in my paper. Now you might ask, oh, is this really happening in forensic science? Are there really any papers who try to do this? Here is one example. Title, Machine Learning Algorithm for Material Sourcing. They don't use the word identification, but the idea is the same, to attribute an item of unknown source to a specific source. I don't show the authors because I'm not interested in talking about authors, I'm talking about ideas that are being developed in literature. So, in order to approach this question, I'm going to address 3 points. First point is to give you an overview of the essential elements of machine learning architectures that are currently widely used, what their properties are, and then to see whether those properties are suitable for addressing the question of forensic identification. And I'm going to anticipate my point of view. My point of view is that current machine learning architectures, the way they are used in terms of off-the-shelf methods, are not suitable to address forensic identification problems. And this is a problem because it means that those attempts, which are unfruitful from my point of view to reconstruct forensic identification, they continue to maintain this idea of identification in the forensic literature. Despite the fact there is a continuous stream of publications to the contrary that provides, or has presented unrefuted argument up to date that identification is fundamentally impossible to achieve. Now just one disclaimer, I do not contest, of course, that identification decisions are being made on a daily basis, because someone at some point in practical legal proceedings has to make identification decisions. I'm talking from an academic point of view, whether the enterprise of forensic source attribution in principle, from an academic point of view, is feasible or not. Because I think this is a preliminary question we need to address before we talk even about who in practice will take charge of identification decisions. So let me start by giving you an overview of the machine learning architecture that is most commonly used and where it is located within the broader landscape of artificial intelligence. And to do so, I ask you to imagine the hypothetical situation in which we say, okay, let's actually try to build a machine that is going to perform identification conclusions. So if that is our purpose that we would like to achieve, then what we need to do is to program a machine. And to program a machine, we must choose a computational paradigm, a particular computational technique, a programming language. So we need to ask the question, what's on the menu? Okay? And this already provides a first limiting condition, because by our obligation to choose a particular computational framework, we're already limited by the features of the method in the way we approach forensic identification. So you see, we don't really start by the properties of forensic identification, but whatever we will come up after having chosen a particular computational technique will be shaped and limited by the properties of the particular computational technique that we have chosen. So what's on the menu? This slide will be difficult to read because of the quality of the beamer, but it gives you a landscape, although simplified, of current and past artificial intelligence techniques and developments. So here on the vertical axis, we have different dimensions whereby we seek to construct artificial devices. And those dimensions are, I need to read my notes. They are perception, reasoning, knowledge planning, and communication. So these are potential capacities that we would like to convey to a machine. And on the x-axis, here on the horizontal axis, we have different computational paradigms that have been developed over the history of computer science. Starting in the 1950s, early years of computer science, we have mainly what is called symbolic AI approaches. They are good for logic programming. Then maybe starting in the early 1980s, we have a computational paradigm that has been coming up called statistical AI paradigms, up to more recent years where you have the subsymbolic approaches. Now, where's machine learning? Machine learning is part of what is called the statistical AI paradigm because it largely relies on the availability of data. So we could even have a discussion about whether there's any use of calling it machine learning, because at the end of the day, if you want to do things properly, you need to observe sound statistical principles. So it's just a fancy name that is now largely used to attract publishers to accept your papers. That's one of my personal critique. Now, in order to understand how the contemporary machine learning architectures work, it is useful just to go a little bit further back historically to look at how programming was performed traditionally before the area of machine learning. So in the traditional framework, the idea was that the program is transforming input data and will provide some output data. This is very, very simplified presentation. But the key point here is that what is being programmed, the assumption was that this process can entirely be encoded by the human programmer. Okay? So the conceptual task that the program should perform can entirely be specified in some symbolic form by the human programmer. Okay? This is also called RUFI, which is good old-fashioned AI, and which is well suited for logic and probabilistic programming. Now this worked out fine for those applications in which we can give a logical formulation of the problem or define a probabilistic procedure, but it is not so easily applicable for other tasks. For example, perceptional tasks. You know, if you want to program a machine that performs perception in the sense of like human vision, it's extremely difficult to program in the terms of a discrete and finite procedure. So here the bottleneck is the fact that there is a certain type of knowledge or capacity that the human programmer himself is not able to provide. So the idea came up to rely on examples of ground truth data. So to process many ground truth samples for which we know whether they belong to one category or another, and to extract information of those samples in order to complete our or the computational procedure. So how does it work? Again, this is a simplified procedure of a simplified representation of the standard machine learning architecture. So we still have, at the use stage, we still have a program, often called a classifier, that is processing an input and is providing an output. For example, an algorithm that is classifying X-ray images as being suspect or not suspect. So it's highlighting up whether some tissue scan shows certain signs of a disease or not. So we're classifying observation into an output label. Or we are assigning an output label to some input label. So we have a measurement, but we don't know to which category it belongs. And example of categories are same source and different source. So categories very often used by forensic scientists. So we still have this classifier which is providing the label to this input sample. But the point is that this function here cannot entirely be specified. So there is still this function which is programmed by the programmer, but this function has certain parameters, and those parameters are learned from the data. Okay, there's a process whereby we look at many samples to find out what are the optimal parameters in order for this function to operate according to certain performance characteristics. This is a brief summary of how this works. Now you might say, what's the point of this type of approach for forensic science? Well, this is exactly my point. That it's extremely far-fetched to use this type of framework for forensic identification. Here is just one example of one classifier that works according to this architecture, which is called the random forest classifier. So here you have the learned model, which consists of many submodels. So you provide this machine learning model with the item which you want to classify in one category or another, same source or different source. And what the random forest does is that it provides us with individual replies from each of the subclassifiers. Maybe if one classifier says the same source, the second submodel says it's a different source, you have a certain number of these submodels. And at the end of the day, you say, how do we finally classify this one? This machine learning model decides on the class to be assigned based on majority vote. Completely arbitrary procedure. Just as an example, and this type of machine learning model is being used by some forensic science papers. Now, question. Assume that we have a machine learning model that has been set up according to these principles, and then ask the question, would it be of any practical use? Would it make sense to use such a model to provide a classification which is to be used as information input or to be presented as part of a legal procedure? So, suppose we have this type of trained model, and we ask the question whether it makes sense to use it. And I think there are three problems from my point of view that limit the use of this type of model for practical application. First problem is the misconception of forensic identification as a binary classification problem. So I'm not saying machine learning architecture is not good or is of no use. There are many applications for which it's very useful. For example, industrial applications, medical applications, where you just try to reduce the work that is being required by humans to classify items. You can gain time, efficiency, sure. But the basic idea of these classifiers is that you can have multiple persons in each category. For example, as soon as you detect COVID marker, COVID virus, the DNA of the virus, if it's detected, the person, it falls in a certain category. And the basic idea is that you can have multiple persons who share this characteristic and fall in this category. And for this type of classification, where this type of applications have been developed, perfectly fine. But there is no analog to this framework in forensic identification, because in forensic identification, it's, if you want to talk in terms of classification, there are as many classes as there are potential sources from which the item could come from. And each of those classes consists of a single member. And the standard machine learning architecture is absolutely not designed to take into account the basic problem or the fundamental problem of forensic identification is that of assigning an item to a single person, which each by herself defines a single category. Forensic identification is not a binary classification problem. I could stop my presentation here because for me it just eliminates this type of architecture for identification. But since I have some more minutes left, I will also present points 2 and 3. Second problem is that at the very beginning I said that there are fundamental obstacles to forensic identification and source attribution. And there's no reason why the forensic interpretation disciplines have moved away from giving categorical statements, but instead give value of evidence assessment. These machine learning architectures just go against those developments and choose the categorical output as an integral part of their procedure. So they just throw up with the development that we have undergone in interpretation of evidence in forensic science. So by building in the conclusion stage, which is a categorical conclusion, in some sort, the procedure defines or attempts to perform real magic. This quote I have taken from philosopher of science Salmon, who has also talked about epistemology and magic, devices that are attempting to perform something that by definition we know we cannot achieve. Now, the machine learners, they might reply, okay, but a model does not need to be perfect in order to be useful. I agree. But it doesn't mean that we should overthrow with basic principles of forensic identification or the impossibility, or we should actually ignore the impossibility of forensic identification and take the contrary as a premise. Third problem is, this is a larger problem of machine learning, is the data centrism of machine learning, because those machine learning architectures, they are predicated on the idea that we can crank out an answer based on data only. And we have been talking about this in the previous presentations this afternoon, that a decision to attribute an item to a person, decisions require more than the data that we have. Whereas these machine learning architectures are based on the presupposition or upon the premise that we can provide, or that the machine can provide a conclusion based on the data only. And that is to say, a machine that has been set up under laboratory condition and has been trained under some sort of training data, which is supposed to be relevant for the actual case that you might encounter if you are requested to think about identification in the individual case. And for example, Kyriakos calls this the radical empiricist agenda of machine learning. And also this goes against how we now perceive forensic identification, or how it should be handled in the context of forensic science and the law. For example, when I say data centrism is not enough, we have been talking about value judgment this afternoon, and specifically in identification, one of the most critical manifestations of value judgments is how we value what is our position with respect to false identification as compared to false exclusion. This is one value judgment which has to be made by some person in the process. So, I'm almost done. Again, the machine learners, they might say, okay, we can fix it. Tell me what I should fix. I said that one of the problems is that machine learning provides direct conclusions, categorical output conclusions. So let's redesign the procedure and just keep that categorical decision aside. Okay, we can do it, we can keep it aside. But if we do that, then we fall back to what common statistical methods are already doing for several decades. Then we fall back to notions such as weight of evidence, likelihood ratio, and so on. So in that case, the machine learning dissolves. Okay. Second point, how we might fix the machine learner. The machine learning architecture is to build in value judgment. So if the problem is that current machine learning does not contain value judgment, they might say, okay, let's build in the value judgment. Okay, you can do this. But then you go back to what decision theory is already doing. And this is just one example here from the artificial intelligence literatures published in the mid-1980s. Come back to Bayesian decision theory. So it has already been done, and again, machine learning would dissolve. And even if we would do it, we would still not have the identification machine or the identification device, because decision theory doesn't solve the problem. It just tells us that where value judgments come in and how they might combine with probabilities, but it does not tell you what the value judgments are. They still need to be provided by a person. Same is true for probabilities. The probability theory doesn't tell you what should be your probability. It's for you to assign the probability. Laws of probability only tell you how you combine different probabilities, but at the initial stage you must provide them. Same is true for value judgment. So again, we can't fix it. So, in conclusion, on those levels of analysis, I have subjective machine learning. For me, it fails on all levels of analysis. And even if you would try to fix those problems, we would fall back to what existing procedures already do. And some of the examples of that are likelihood ratio procedures or other statistical procedures. What statisticians like Carole and Edmond and you have published a guideline as part of a series of guidelines issued by the Royal Statistical Society on explaining how probability might interact or might be used in the law, we would fall back on those principles. This was a very shortened presentation of a longer paper I have written, which you can download here if you're interested. And I thank you very much for your attention.